Good morning, Your Honors, and may it please the Court. The threshold issue in this case requires that the Court interpret Section 3005A4 to determine the full scope of criteria for human remains that qualify for repatriation under that provision. Now, this Court has recognized that to determine the plain meaning of a statutory provision, the Court doesn't look just to the language of the provision itself. It also looks to the context of the language, where the language appears, and the broader context of the statute as a whole. Now, that principle is particularly important in this case for two reasons. First, one of NAGBRA's purposes is to provide for the protection of Native American graves, to protect them from disturbance and protect their contents from being disinterred.
But does that really apply here? It's not as though anyone... These were burials without consent. There was no Native American burial. These kids are kidnapped, dumped in a grave after they die at the government's hands, and then moved so that they can pave over the graves with a road. Do you think Congress's point was we really need to preserve that setup?
No, well, Congress, ultimately, this statute is to preserve graves. So notwithstanding how the burial might have occurred, it's so that the graves... So that the graves aren't disturbed. So, for example, someone just can't come along and say, I want to take these remains on the road and show them to everyone, so disinter them. It's to protect the graves so that if they are disinterred, it's for a reason that's consistent with the statute. So while the Congress also provides for the protection of the graves, it also provides for the repatriation of items of Native American items. But in keeping with that objective to protect graves, Congress allows for repatriation only under specific and limited circumstances. Now, there are three interrelated sections in NAGPRA that address those limited circumstances, and importantly, they do so sequentially. In Sections 3003, 3004, and 3005, Congress sets forth a sequential process that certain museums and federal agencies must follow for the repatriation process to occur. Now, Section 3005A4 at issue here is the last of the steps in that sequence. And what that means for purposes of statutory interpretation is that Section 3005A4 does not exist in a vacuum. Rather, it builds upon and is substantively dependent on the preceding steps in the repatriation process, namely 3003 and 3004. So therefore, 3005A4's criteria for human remains, which is what the issue is about here, cannot be determined by looking at that provision in isolation. The criteria for human remains in 3005A4 must be interpreted building on the criteria for human remains that's already been defined in Section 3003. So if we focus on just the two provisions that regard human remains, those are 3003 and 3005.
Well, maybe she misunderstood my question, but the district judge ruled that the remains at Carlisle Cemetery did not qualify as a holding or collection under the statute. Mm-hmm. That limitation really frustrates the intent of this statute under these circumstances, where there's no consent and there's a reburial.
Well, Your Honor, I appreciate your point, except the statute says nothing about, in terms of this repatriation and these three steps which govern repatriation, about consent. What it's talking about now, it has specific. For example, I was about to get to Section 3003.
Well, before you do that, maybe you can address it. Had the district court found that this was a holding or collection, then their repatriation would be simple, would it not?
If the government found that these remains were in a holding or a collection.
And so my question is, insofar as a holding or collection, those are common words, and you can go to a dictionary and get a definition of a holding, and when it talks about some of the things that can happen is that for public benefit, like a tour and that kind of thing, the graves are out there for people to read about it and see the graves, etc. Doesn't that get into a position where the tribe can repatriate those?
No, going back, we have to focus on the provisions that speak to repatriation, because that's what's being sought here. They've sought repatriation under.
But I thought your whole position is, the way you are reading Section 30054, it can only be repatriated if it's part of a holding or collection.
Yes.
And Judge Floyd is saying, great, why is this not part of a holding? So I don't see how going back to your textual statutory argument.
Well, it's just that 3003 is where holding and collection, that describes the universe. In Section 3003, it describes the statutory universe of remains that are subject to the repatriation process. That's where we begin. That's step one in the repatriation process. And in Section 3003, that's where it says holdings or collections over which the federal government has possession or control.
Great.
That's our starting point.
Okay, I actually disagree with that, but that's where Judge Floyd wants to meet you. So why is this not within that provision as part of a holding?
Going to the dictionary and regulatory definition of holding or collection, it's the gathering or accumulation of objects for specific purpose or reason. Those are the definitions. If you look at both the dictionary definition and the regulatory,
the regulation doesn't say specific purpose. It says any purpose.
For
and I have to say, you made that mistake several times in your brief, and I thought you were very close on the duty of candor. It does not say specific purpose. It says the opposite. Okay.
Okay. Well, before a purpose,
it says any purpose.
Any purpose or reason. Therefore, there must be a purpose or reason associated with the gathering and accumulation. And here, there's nothing alleged in the complaint that says that the government gathered or accumulated these remains for purposes that are in any way consistent with the definitions.
So if tomorrow the government disinterred these remains and put them in a glass case, you would say they are not part of a collection or a holding because that's not why they were originally gathered or accumulated.
That's a separate issue. Anything that's interred after the passage of the statute,
disinterred. But it would still not fall within the definition of a holding or collection, in your view, because that only applies if the original purpose was to.
Well, I'm just saying in this case, I'm starting first with the original purpose, and I'm not saying original is in a definition. I'm saying here, because we have remains,
But they're now part of a historical tour. It's like an outside museum.
No, the remains which are at issue here are not displayed. There is no showing of the remains. There is no exhibition of the remains. There is no display of the remains. And the public is not given access to the remains. It's the cemetery, which is now located on the military barracks. So if we go with the allegations in the complaint, if individuals are on the barracks, there is a cemetery in front of them. And the military has simply said a fact, which is this is a cemetery which holds students who used to be enrolled in the Carlisle School. That doesn't speak to how gathering occurred, if there was gathering. It doesn't say that the government accumulated these remains for purposes of displaying them, because indeed they're not.
Does that go to the point that, how does one gather or accumulate human remains? You have to disinter them, right? The remains, this is a grave. This is a grave site that's not, the remains become accumulated or gathered by disinterring them, and then you have them and can collect or hold them. But the statute just seems to say, it seems to talk about human remains in a grave in very different terms, right? That they are not held or possessed by someone until they are unearthed. Is that
those are different provisions. You're speaking to 3002, which goes to ownership. We're talking about here now to back up.
Well, I think I'm trying to interpret what you were saying, that you were saying no one can look at the remains when they visit the cemetery. No one can, and I think I agree with you in the sense that it's not the original purpose, right? Why were these children brought to the school? They died there. Why were their graves moved, et cetera? But the question instead is, have they been have the remains been accumulated? Have they been, and the only way to get the remains is to disinter them?
Well, it hasn't been done. They haven't. Right. The remains have not been accumulated. But museums, for example, do accumulate remains, and they right. For example, preserve them and they display them. And if they haven't displayed them immediately, they put them in airtight locations away from the light, so they are preserved and conserved, so they can be studied at some future time or exhibited. That's not been done here. What was done was when the students passed away, they were buried, they were interred. There's no gathering. There's no purpose associated with it. Then they were disinterred, okay. And they were moved to another location where they were again interred. They were buried. They were not displayed. They were not shown. They are now in a cemetery. None of that is consistent with gathering objects for the purpose of researching or showing or studying them. Nothing has been done, and the Army has had no purpose, and the complaint alleges no purpose of the original burials or the secondary that was for purposes of exhibition. The relocation took place in 1927. Whatever's been alleged now in terms of what's happening in the recent history at the barracks is simply that there's a sign in front of the cemetery. There's not an allegation of how this gathering or accumulation allegedly occurred. And there's not a purpose. There's nothing in the complaint that says that the purpose in 1927 was to exhibit these remains. Nothing associated with what has happened with these remains thus is consistent with any of the definitions of holding or collections. But I just ask the court to understand that we are trying to explain and follow the statutory language, which is simple as they said. It's a repatriation process that's set forth in 3003, 3004, and 3005. That's what. Of
course, 3005 says not included on an inventory. And we can read in inventory means inventory of holding or collection, but your argument is asking us to interpret the not to mean not included on the inventory but should have been, right? Well, not included on an inventory but is in a holding or collection.
It doesn't even need, you don't even need to finish that awkward sentence about not included in such an inventory. What's important about that provision in A4 is that there are two categories of remains, one for which cultural affiliation has been established and one for which the remains are not included on any such inventory. What's important about both of those is that they're tied to the inventory provision. Congress didn't say remains for which there's a cultural affiliation and then everything else. It tied it to the inventory. Both are tied to the Section 303 inventory, which makes sense because this is a sequential process. Museums and cemeteries have to do an inventory for certain remains. That becomes the universe of remains with which we work. Section 304 says for objects, not human remains, you do a summary. And then 3005 harkens back to each one. 3005 harkens back to the inventory in Section 3003.
Well, Ms. Wright says these children died buried in 1927, and they can't produce the affidavits of the next of kin. How are they ever going to be able to repatriate the children under your interpretation of
those are separate, entirely separate. The statute is one thing, and it doesn't. What's being asked of for return under the Army's regulations, which is separate and apart from NAGPRA, from the statute. That's separate, and the Army has said, if you don't want to take the NAGPRA statutory route, there's a regulatory route you can choose if you want remains returned to you. And that's the one that requires the signature of the closest relative.
If that's the Army regulation, they can't comply with it, so they have to go through the statute.
Well, Your Honor, both the statute and the regulations have certain requirements and conditions, and if an entity can't fulfill that, that's something I can't speak to. But the regulation is trying to prevent, for example, just anyone saying, I want those remains. I'm not a relative, but I want the remains.
And I do not disagree with that. That would be a wholesale problem for the United States. But in this particular case, what I was trying to figure out, well, here's a cemetery that's been is advertised is the wrong word, but I mean, it's out there for people to view and encourage to see that there were children that were in this school system back in the late 1800s and 1900s. They died, they're buried here. The tribe wants them back. And
two things. There are two ways they can get them back, either by the statute, and Congress has just simply put in conditions and limitations and criteria, and that's what we're stuck with. And the Army has no authority to disregard what's in the statute. In terms of the regulations, it's another option. It's an option that the tribes can seek. I would just like to say. Go ahead.
I don't want to cut you. Finish your point, and then I'll come back.
I'd just like to say that there's no allegation in the complaint, though, that there's any affirmative sort of encouraging people to come and look at the cemetery. But I also offer that doesn't the complaint allege that it's like on the website or something, that the cemetery offers visitors a glimpse into the unique past of the United States and Native American history? I mean, I feel like that is inviting people to come look at the graves. We accept the allegations as they are, but what I offer is what the Army is doing is acknowledging that on its barracks there is a cemetery where these children are located. Well, it can be that the Army just takes the sign down, but it most certainly is not.
Well, this is here on 12B6, so as Judge Harris pointed out, why isn't that sufficient to get by the 12B6 motion? As to that is purely, the 12B6 is purely on the pleadings. So why did that allegation get them by the 12B6 motion?
Why that allegation?
Why does the allegation that she read to you not get them by the 12B6 motion?
Oh, well, it's in part it's simply because it's a naked assertion, and this court has recognized in Cortez that a naked assertion that's not that's devoid of further factual enhancement isn't entitled to credibility. But I will let's just assume that what they say is properly pled. The point is that the government is simply acknowledging the presence of these remains. And in many ways, I shouldn't speak personally, but I think it's a good thing that the government acknowledges that they're there. The other options we ignore. We ignore that they have existed. We ignore where they are now. But there is nothing in the complaint that establishes that either in the first instance, when these children originally died, that their remains were gathered and accumulated for the purpose of exhibition or research or study. And there's nothing in the complaint that establishes when they were relocated that the government did anything but just inter them again.
Can I take you back to that act? Because we are on 12B6, which would seem to say, only if the statute, if there's no way to win, right? Does the act say anything about the control or who has control of buried human remains?
Not for purposes of repatriation.
I mean, anywhere in the act.
Well, Your Honor,
is that saying who has a right to control still buried human remains?
Still buried. I do not.
I didn't see anything. I mean, there's provisions about if remains are excavated, if they are discovered, which has a regulatory definition, which means excavated without permission. If remains are disinterred, then there's a provision that explains who has control of that. There's detailed provisions about who has a right to possess those or control those. And then other sections of the statute have to do with remains in, like we've been talking about, holdings and collections, right, which they are held by a museum for the reasons we've been talking about. And it explains who can control those, who can possess them, who has a right to request to have them back. I didn't see anything in the statute about who has the right to control human remains that are still buried in the ground.
I I don't know of any such provision, and it may likely be because that speaks to, if you will, a cemetery in which individuals are interred.
Well, it's silent, right? And if Congress is silent about something, we presume that they had nothing to say about it, right? And if a statute's silent, it doesn't create an obligation.
Well, I think that your colleague's response, and I do want to give you a chance to respond to this, is it's covered by 3005A because the remains are possessed and controlled by the federal agency, and that the way this is supposed to work is under, let me make sure I get this right, under 3005A1, those are cases where remains have been disinterred and are part of a holding or collection now, and in those cases the burden is on the government or the museum. Do an inventory, your burden. Inventory it, try to figure out cultural affiliation, and give the appropriate notifications. And if 1 and 2 don't apply for whatever reason, including they're not part of a holding or collection, then now the burden is on the tribe. And under 4, they have to come in and establish cultural affiliation, and at that point they get repatriated to the tribe. Why isn't that what the statute says?
Well, under 3005 in its entirety addresses the universe of human remains that are subject to repatriation, and that's established in 3000.
Wait, I'm sorry, just say that again. 3005 in its entirety applies to what?
Speaks to the universe of human remains that's already been defined by 3003 and 3004.
I don't see that.
That's if you look at 3005 A1, A2, and A4, all speak to either Section 3003 or 3004.
Right, but I don't understand that to me doesn't answer the question. A says, and I understand you think the heading is wrong, we should ignore the heading, but A does say this thing speaks to human remains and objects possessed or controlled by federal agencies and museums. Sometimes the burden is on the person or the agency or museum that has these remains as part of a holding or collection, inventory it, figure out cultural affiliation, and make notifications. And then under 4, as I read 4, it's just saying when subsection 1 and 2 are inapplicable, now the burden is on the tribe. The tribe has to come forward, show cultural affiliation, and at that point, the remains are repatriated. I understand your argument that this is you have a different reading, but this doesn't strike me as like a model of clarity or disambiguity going your way, especially because you do have to say the heading is wrong. When Congress said what this speaks to.
And we've never said the heading was wrong.
Okay, then how come it seems to say it covers all objects possessed or controlled by federal agencies and museums, all human remains?
That is indeed what the heading says. But this Court has acknowledged that what's in a heading doesn't limit the actual text of the statute.
I said is wrong.
So the question is
inartfully drafted. It should have said holdings and collections.
Fine. So the question still, the Court has to recognize that nothing in the text of A4 speaks to possessions or possession or control. So the question becomes, and the government doesn't dispute that possession and control is an element.
Just so I truly don't quite understand what you're saying about subsection 4. Would your argument be different if subsection 4 had simply said something like in all other cases, or where subsection 1 is inapplicable, then Native American human remains shall be expeditiously returned where the requesting Indian tribe can show cultural affiliation? Does your argument depend on the fact that they actually said the words not included on an inventory rather than where Section 3003 is inapplicable?
Well, it would be much clearer, and we couldn't rely on Section 3003 if Congress said Section 3003 is inapplicable. It's just that Congress clearly harken back to 3003 and define human remains in A4 only in terms of the inventory in Section 3003.
It doesn't say that. It just says they're not included on an inventory.
Inventory. What inventory is Congress speaking of? The inventory in
the
Section
inventory
3003.
that didn't get done because they weren't part of a holding or collection.
It doesn't say the inventory wasn't done, but it still harkens back to 3003. We can't extricate 3003 from the interpretation
of
A4.
Course you can't, because the obvious point, I think we all agree that where 3003 is not applicable, like as part of what Congress is saying, you're saying that Congress is specifying that the reason it's not applicable is because it should have been on an inventory, but it wasn't.
I'm not saying that. I don't think Congress is saying that it's inapplicable. If Congress was saying Section 3003 is inapplicable, it most certainly would have said that, because the only reason we have an inventory to speak of in 3005 is because the inventory is required as part of the repatriation process pursuant to Section 3003. And the point I'd like to make about the heading, I understand the heading's there, and we're not disputing that part of the definition of criteria for remains that qualify for repatriation includes possession and control. But it's not because we drag it from the heading. It's because it's in Section 3003. It's because Section 3003 says holdings and collections over which a federal agency has possession or control. It's a package, if you will, of criteria. And as I said, it's the universe of criteria that apply.
So if 3005A4, this little clause about not on an inventory, if we interpret that clause to without saying it in as many words, to actually mean and all cemeteries where remains are still buried, right? That's what we're doing. We're reading that to mean all remains, or that's what your opponent wants to do, is to include cemeteries. Then we would have to go through back to 3002C, right? Because Congress specifically limited the intentional removal from or excavation of Native American cultural items, which includes remains in the definition. Removal of such items is permitted only if, and then they lay out 4 requirements, right? And so you have to intentionally remove or excavate those remains before you can repatriate them. So you seem upset. I'm asking something that I think you're going to want to agree with. I'm just going to give you the answer before you respond. I'm baffled we have these requirements that we would have to go through, is my point, for human remains that are still buried, that these requirements don't apply to excavated remains and cultural objects because they're already out, right? But if we're going to interpret this clause in 3005A4 to kind of backdoor in any cemetery without consent, then we have to apply 3002C. That is a really complicated question. Do you understand at all what I'm saying?
I believe I do not, but I.
That's fair.
Any non-poker face where I'm showing emotion is because as I understand, and I just realized 3C was cut off, but 3002 goes to ownership, and it goes to a particular time frame, which is after the passage of the act. So
right. 3002A is about anything that's excavated or discovered after the act, right? And that's what you would be doing. You would be excavating these children's remains after the act.
Correct.
Right? And then C says you cannot intentionally remove remains from the ground unless you do these 4 things. It has requirements for that. That would apply here, wouldn't it?
Your Honor, I'm so sorry. I cannot speak to that because the title of this is ownership, and it doesn't speak to repatriation as I understand it. As I said, I understand that process to be the 3 sections I've spoken to. Right,
but just like kind of practically, right, you can't repatriate human remains unless you disinter them?
Well, yes.
Okay. And Congress is limited when they can be disinterred?
Yes.
Thanks. Sorry.
All right, well, we have taken you way over your time. Apologies. And Ms. Wright, you have a few minutes for rebuttal.